welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Krishan Singhania with us. Mr. Singhania is the managing partner and founder of Singhania Co. He is a seasoned professional with comprehensive experience of 30 years, actually over 30 years. Singhania Co. has had unrivaled success under his dynamic and determined leadership. His legal expertise in corporate and commercial law, including arbitration, aviation, foreign direct investments, is highly respected in the industry, and his ideas and opinions can be found in popular legal newsletters and international journals. He has consistently been ranked amidst the top 100 lawyers and legal icons of the country in the annual A-list feature of India Business Law Journal as well. Owing to his experience of working as a foreign lawyer in New York and London, he brings international best practices to the firm. Without any further ado, let me just introduce you to the man himself, Mr. Singhania. Hello, Krrishan. How are you?
Fine, thank you. I thank LexTalk for giving me this opportunity to speak to you and about myself and my firm.
Oh my God, anytime, anytime. Thank you so much, Krrishan. It is obviously a pleasure having you here. We're really excited to know about your journey as a legal professional. So we are really going to dive deeper into your expertise, and we would really love to know about the complex issues that you have worked on. So we'll start with my favorite question. We would really like to know about any complex issue that you have worked on, and if you would like to describe the complexity of it and how did you approach the matter?
I will discuss with you a few cases, even though I have dealt with a number of cases of this nature. But some of the important cases which I have dealt is one relating to enforcement of international arbitration award in India. This was a case where a foreign party has entered into a contract with an Indian party to supply aluminum rods. And in 1991, when there was a foreign exchange crisis, the Indian party refused to honor its contract by saying that we are discharged from our obligation because of exchange crisis in India. But in the contract, there was an arbitration agreement. And as per arbitration agreement, the contract, both parties went for arbitration in London. And when our London arbitrator gave an award in favor of foreign party, the award came for enforcement in India. The peculiar issue in this case was regarding that the contract was not signed between the parties, and secondly, that whether restriction by Reserve Bank of India or by a foreign exchange crisis discharged the Indian party from their obligation. In this case, even though there was an unreported judgment of Bombay High Court, which dealt about a signing of the contract, an international contract for arbitration, but the court took a different view. Court said that there are two stages in arbitration. One is prior to matter going to arbitration and post-arbitration. So the Indian party's plea that the arbitration agreement was not signed was rejected by Bombay High Court. And secondly, they upheld the arbitration award in the favor of foreign party. After this award was passed, the Indian party was not satisfied and they filed an appeal in Supreme Court. In Supreme Court also, they took the plea of public policy of India. They say that court should not enforce an award which does not consider Indian law. But still court said that Indian public policy for under Arbitration Act, particularly international arbitration, is not that Indian parties should not honor their contracts. And they decided against the Indian party and the award was enforced. This act of Supreme Court gave a lot of confidence to foreign parties and Indian parties to go for international arbitration and see that the award will be enforced in India. Second, another interesting case was where there was a contract between our international client and a domestic party, where our client had appointed a distributor for its goods in India. Thereafter, they had cancelled the contract of the Indian party. Indian party went to Bombay High Court and challenged that cancellation of the agency agreement. Our client had in the contract, it was written in the contract that in case any party which files a case against the other party, they will have to go to the jurisdiction of the other party. In this case, since it was a foreign party's claim was against foreign party, they had to go to a foreign court. But instead of that, they had come to Indian court. Luckily, when we took an innovative approach and we argued in the court the court has to honor the commitment of the parties and honor the contract. And the Indian Bombay High Court held that the Indian court had no jurisdiction because parties by agreement had agreed for foreign court jurisdiction. So that was another achievement for us for showing that the courts are considering what is the agreement of the parties. And the third interesting case which I feel is in our cabinet was with regard to an office of a license office, where an Indian party had a contract with a foreign principal office of that license office, and there was some dispute between the two, whereas they thought because of the license office, they can file a case in India and file a case against the Indian license office in Bombay High Court. In the history of Bombay High Court, first time Bombay High Court upheld the jurisdiction, said that they cannot file a case against the Indian license office because Indian license office had no role to play in that contract, and as per law of RBI law, Indian license offices of a foreign company are not allowed to do business. And again, it was registered in a reasonable period of time. So these three cases I feel in our professional career are important because they showed that courts are in India also working expeditiously and also seeing that justice is done. That are the three important cases which I feel I would like to share with you. And another important case which we had dealt was with regard to an aircraft lease. In this case, our client had leased an aircraft to an Indian operator in the beginning of 1991, and there was a breach of the lease agreement. We were able to file a case in Bombay High Court. Even though the contract was governed by English law, still Indian courts upheld the right of the foreign lessor to terminate the lease and take the aircraft back. This was a very interesting case because during this case, when we got the order for release of our aircraft, the opposite party tried to stop us in many ways. And one of the ways they were trying to not allow us to take the aircraft on a festival of Holy Day, that was a holiday of the court, they tried to stop us from taking the plane back to the parent country. In that circumstances, we had to move the court in the house of the judge in first time in history of Bombay High Court. And the judge was kind enough to give an order allowing us to take our aircraft out. And that gave us a lot of satisfaction that we could get relief for our client in such circumstances also, which we had never contemplated earlier. So these are the few cases which I felt that I should share with you, where complication was there, but ultimately we were successful in getting relief to our clients.
That's absolutely lovely, Krrishan. And like, is there anything else that you would like to share with us?
No, with regard to cases, this is our general, and secondly, no doubt we get opportunities to speak to audience and discuss law reforms.
Absolutely. And I'm really glad that you shared these cases and their complexities with us. Thank you so much. Now, my next question would be that the pandemic has seen a lot of, courts. Actually, we are living in the era of technology, so we are into the world of remote proceedings. So is this sustainable and like a possible way to increase access to justice? Like, what's your take on it?
So we think that this is a way to bring access to justice for a longer duration, not only during COVID, because this is giving an opportunity for many cases to be heard at a shorter time frame, and also that with the safety and security of working from your office, from home. And secondly, the other advantage is that this model can be followed in many remote parts of India, where justice was not available, particularly for parties who are not present in Mumbai or in metro cities, and they have court cases which have to be dealt in the metro cities on high court level. So this is a sustainable model. Only thing is that in this model, we have to also remember that there is a difficulty of access to justice in the sense of electricity and also of devices and bandwidth. So we have to, see that also in mind. So maybe for some time we will have to keep both the forums open physical and virtual, so that more and more people get used to this system, and then it can definitely help the litigation process and the litigants.
Of course, absolutely. Thank you very much for answering that question. Now, Krrishan, how would you rate like the current legal system drive towards encouraging like the access to justice? I'm sorry, I'm using this word again. These words per se. Is there like a tangible movement in closing that justice gap?
No, there is definitely a gap because the number of judges which we have in the system and the number of cases we have, there is a vast difference between the two. So one way to definitely increase number of judges and to draw the gap is to, appoint more judges plus also use the technology so that we can streamline the litigation procedure and process so that more and more cases can be taken up in a shorter period of time and people can get access to justice by that means. And secondly, one more advantage which I see is that the distance gap between a judge and an advocate gets reduced during this process. No doubt, the system to some extent has some shortcomings, in particular with regard to taking up evidence or multi-party litigation, where number of counsels are appearing in one matter. Then it becomes a slightly difficult position to go through a virtual court. Whereas in physical court, the judges get a chance to look at the demeanor of the witness or hear many counsels, in particular in a multi-party litigation. So there is little advantage in that in physical form. But as long as this pandemic fear is there, I think this is the way to go ahead and continue with both physical and as well virtual courts to continue.
Lovely. As we have already actually talked about, the remote proceedings and how is that sustainable. So obviously, technology plays a really, really important part when it comes to today's world. So in this era of legal technology, what are the mostly common, most commonly used tools for you?
No, the most common tool which we are using is Zoom, then WebEx and Google Meet, particularly for both for our internal work, for client meetings, and also holding arbitration meetings with the arbitrator, which were being done earlier physically. And secondly, with regard to the court proceedings also, they are also being done on Zoom and WebEx. So that again gives an advantage and opportunity, to be physically, virtually present in court without taking the risk and time to do so. And some advocates are taking advantage by using this technology for different courts also. Even though they may be in one city, but they can appear in other different high courts. So that is one technology advantage which we are seeing. And other technology which we are using in our day-to-day is no doubt artificial intelligence for softwares for doing legal research, management documents, management working on one document in multiple advocates together. So whatever comments we have to make, client is also working on the same document. So that makes it physical, distances to little less, because now things are getting done on a faster pace.
All right. Thank you very much, Krrishan, for throwing light on that as well. Now, like as a lawyer, I would really like to ask you about your time management. Like, how do you ensure that you make the best of your time as a lawyer?
No, best of frankly speaking, because of the time constraint also, because now we don't have large number of people working and giving us assistance. So now definitely we depend on technology, particularly for documents management. Then we depend on legal research. That legal research has to be done in optimum manner. So we are using software. Third is that one of our areas specialization intellectual property, and particularly trademark. So in trademark also we are using artificial technology to watch that trademark search is carried out through technology. And fourth is that we are using also for legal research and like also to connect with number of people at one time. So this virtual tool is helping us to save time and cost.
All right, great. Okay. Actually, I've asked you mostly everything, Krishan, and you have covered everything so beautifully. You have put it into words so beautifully. But one thing that I really am interested to know about is that what inspired, like, what actually inspires you about the future of the legal space, about the future of law. Maybe let you can we can talk about, like, on the national level or on international level, however you want to say.
No, future of, I think, law is more toward dispute resolution, and dispute resolution in the sense in alternate method. What I see is today that if law has to survive and it has to expedite, so one is that we have to go use technology for document management, standardization of pleading, standardization of case management, and also fixing time limits for arguments. No doubt recently Supreme Court had taken in one case where both parties were directed that they should do it in a limited number of hours, a hearing of a case. Similarly, if courts get active, then future of law will be secure if number of cases are limited. Disposal rate improves in the court, and parties are aware that when their cases will be taken up. And I believe that in case we create more awareness about both domestic and international arbitration in tier 2 and tier 3 cities by either doing seminars or giving training to more people to act as arbitrators and use this method for dispute resolution, for business disputes particularly. It will definitely go in a long way to encourage more young lawyers to join the profession as either arbitrator or as counsel and deal with these cases, which will definitely help economy as well as the business community in resolving their disputes. That is what inspires me that, and therefore we are also making our efforts by giving our suggestions to different chamber of commerce and writing articles on the subject. So that is where I see the future of law lies in alternate dispute resolution.
That's amazing. Thank you so much for throwing light on that, Christian. Now, what is or what are your views on the legal reform, and how do you think it can help litigants? Sadly, we are coming to an end of this interview, but I had to ask you this question,
So,
considering
see,
the kind of.
one of the thing which litigants are now, a little bit frustrated is the delay in disposal of cases. So one way is no doubt to increase number of judges so that cases can be more heard, more cases can be taken up in a single day. The other way which we think is that if there are standard pleadings for courts, there is a standard timetable for court procedures. And also there is a more written black and white pleadings and written arguments rather than oral arguments. This will shorten the time available to the court, but this will expedite disposal of cases, which will result in judgments and orders, which is what a litigant wants. So if we go in that direction, no doubt recently what the reform has taken place is that instead of the legal size, now we have gone to A4 size of paper. Similarly, if we standardize the pleadings and we know that what are the rules for each court and they are available on the website of the court and a timetable of 30 days at least, then this will give a lot of strength to people to be ready. And then that old saying that date after date in courts will stop. And that is very important. And fourth and last is that courts have to recognize that, see, delay in decision making is also delay in justice. And that is no justice, according to me. So it is very important that we make time-bound case timetable. The case starts and case ends in a particular time, which will go in a long way in helping litigants to come forward and take up cases which are genuine and also avoid frivolous litigation in courts. That is equally important. That is what I see for the future of litigant, future of law and litigants.
Thank you. Thank you very much, Krishan, for this wonderful interview and for sharing great insights about everything that we've just shared. It is obviously a pleasure having you with us, and we would really love to connect with you again for some other trending topics in the legal space. And for our viewers, if you like this chat with Krishan, please like and share this video, and also subscribe to Clickaway Creators YouTube channel to appreciate what we do. and you have more coming from industry legal leaders like Krrishan. Till then, take care, stay safe, bye-bye.